I kind of almost like trying to hold my tongue up, like I was like, oh, it's so like, it was like topical, but like, hey, hi, good, how are you? I was thinking forever. No, you just look sad. I don't know, I think you look tired, but that might just be me with like projecting. Nah, I haven't. Yeah. My weekend was too bad.
Yeah, I know. Literally, I think I didn't present so.
You can put it down. You put it down as far as yes. Just put it down. Hi, and welcome to this, the first of the Moving the Law series of public events. Let's call them events. I want to begin by acknowledging we're on Aboriginal land that was never ceded following invasion, the land of the Palawa Pakana people of Lutruwita. And I want to pay respects to elders past and present and to the emerging leaders in the Tasmanian Aboriginal community who continue to fight for social justice and human rights and for land rights and more. Before we get into the detail, I should introduce myself. I'm Robin Banks. I'm a PhD candidate at the University of Tasmania in law, discrimination lawyer, human rights lawyer, public interest lawyer, I guess is the way I describe myself. Nicole, would you like to just briefly do a little description?
Thank you. And I'm Nicole Sommer. I'm a legal director at the Environmental Defenders Office. We're a national not-for-profit and charity focused on environment protection. My program focuses on human rights and the environment and environmental justice.
Excellent. The housekeeping, if there's an emergency exit is there, and I think the oval is the congregation spot. I could be wrong about that, but it seems like a pretty safe place to go in case of an emergency. Just remind people about COVID safe. A bit of distancing would be good. Some of us can't wear masks because we're presenting, so the more of you that wear masks, the safer I'll feel, which would be really nice. Thank you. Don't have to. There's hand sanitizer out on the table outside, and I see some here as well. Toilets, if you need them, are in the Centenary building. Amazingly, there aren't toilets in this building. That seems astounding to me. You'll need a swipe card if you need to use the toilet. So if you're not a member of staff or a student, grab Cleo over there.
Chaperone.
Not chaperone you, but lend you her swipe card. If you could turn your phones on to silent, that'd be fabulous. So we don't have disturbances. And before we get into the conversation we're going to have, I want to really acknowledge particularly Cleo for all of what she has done to make this happen. And she's drawn a few of us into it, but has really done the bulk of the work. And my colleague as well, Yvette Maker, who's been involved. But also really want to thank TULS, the Tasmanian University Law Students, something, name, Fletcher, and all of your colleagues for being supportive of this as well, and to the law faculty and the Dean, Gino Dalpont, for his support. Really important. It was a bit of an idea that got floated and it's turned into something that's always good to happen. So Nicole and I are going to have a conversation, and we really want you to join in if there's something that we're talking about that you really want to ask us about. And there's going to be hopefully plenty of time to have the conversation as openly and interestingly as possible. And we're talking about public interest lawyering and what it means and what the barriers are. So Nicole, want to start? Will I start?
Robin, why don't we start with
you? Okay. So I come to this with a background in, I guess, as a public interest lawyer, and I've had the privilege of having perhaps the best job in Australia in public interest lawyering, which was as the CEO of the Public Interest Advocacy Centre. And that's like public interest lawyering on steroids, where you get to do litigation work and legal research and social policy research and engage with all levels of government. to try and achieve public interest outcomes using the law. And that's really the one condition that we had around it, was it had to be a legal strategy of some sort, not just litigation, but others. I came to that having been an advocate with people with disability in Central Australia, and then in Sydney. I had I saw lots of disadvantage, and I guess that's really why I decided to do law. Was I thought the law has to give me some tools that I could find useful. And certainly I think public interest in lawyering gave me some tools that I still use and teach and do other things with. And I guess I often see public interest lawyering in the context of people who lack political or financial power, seeing the law as a strategy to move change, to try and achieve an outcome. It doesn't always work, but I think it's, often if you don't have political power or media power or, the ears of people in government, then it's a way to get attention. Public interest lawyering, and certainly public interest litigation is a way to get attention. So that's me. What about you, Nicole? What's your lawyering?
Yeah, it's interesting, and I was thinking about this. I'm a really great example of a public interest lawyer that's really come to that career quite late, and it's been a life-changing experience for me. And I know that you know that I was going to say that, but it is really a different perspective on the practice of law and the legal profession. Has opened my eyes to systemic injustices in the way that we practice law and the way that lawyers work. And I was a person who started, my career. I was an environmental law student. I wanted to be an environmental lawyer. I thought I was going to change the world, and then I needed to get a job. I needed to go and get a job. And I went into the Department of Planning. I worked against public interest lawyers who are now my colleagues, the EDO, and I came out the other side in private practice. And I tried to fulfil my desire to live my values through other means, joining organisations like Australian Lawyers for Human Rights, which is how I first met Robin, and volunteering and trying to do pro bono work. Then when I was 8 months pregnant, the gig came up at the Environmental Defenders Office in Tasmania, and I couldn't let the opportunity pass by. And Jesus, I really am glad that I didn't, because it has been a complete transformation of the way that I think about the law. And I've really gone on a personal journey over that time, which I think is what is so valuable about the practice of public interest lawyering. I think one of the things I wanted to do is acknowledge that what we're talking about here is our Western system of laws, and our Western system of law has been a tool of oppression for many people, in particular First Nations people in this country. And there is another system of law in this country, in operation, first law. And I think that that's something that we as a society are starting to grapple with, and we're starting to grapple with it in the profession as well. But that's something that we should acknowledge in the context of talking about public interest lawyering. I'm really coming at it from a very Western legal background. I've been really trained in as a lawyer and an advocate in courts, and that's how I think of the law. But my work at the EDO, the thing that I love about our work is that what we do is we use the law as a tool for change for the environment. The environment is a voiceless being. It's something that's out there, but we work with people who want to make a difference in the biggest issues of our time, climate change being the natural one for me to say, but also the extinction crisis, the pollution crisis, and working with First Nations as well. It's an area of law that we can make a tangible difference in the outcomes for people and for society as a whole, and it sits really within the context of social movements, which is what Roen mentioned. Sort of, if you look overseas at the Black Lives Matter movement, there's this concept of movement lawyering, being engaged in the movement and how you ethically engage in the movement as a lawyer. And I think, those things make you sit with discomfort in what it means to be a lawyer. And I think that's a really valuable part of being a public interest lawyer. I just wanted to mention this one quote from a lawyer I admire from the US, Vincent Warren from the Centre of Constitutional Rights. He says, you can change the world with a lawyer, an activist and a storyteller. And what I love about my job is that you can do all of those things. And I absolutely, that's public interest lawyering for me. That's what makes me tick.
You're talking about how you know, it's sort of life-changing coming into the EDO. I remember I left, I was in private practice before I went to the Environmental Defender's Office, and I was a senior associate, and I got the job at the Public Interest Advocacy Centre, much to my shock, because I didn't think I was going to be the best candidate. And one of my colleagues, who was also a senior associate, said to me, God, they must be paying you a lot. I was like, yeah, no.
So, you know, exactly the same.
Yeah. They must be going to pay you a lot. It's like, no, I'm taking quite a big cut. Well, why would you do it? It's like, well, because I think it's probably the best job in the world for me. But and about 5 years later, he went from there to Goldman Sachs. I went from there to PIAC, and he was in Hong Kong with Goldman Sachs, and he came back to Australia. And the next time I saw him was at a community legal centres conference, which was the last place I expected to see him. He was doing sort of bankruptcy law and stuff like that. And he ended up in a community legal centre, and he came up and he hugged me. He said, thank you for making me see this was a possible way to practice law. And he had just completely changed his view of the law and legal practice as a result of coming into the community sector and, you know, one version of public interest lawyering. So, yeah, it sort of can be life-changing. It has been for me, but it was even more so for him, which was really lovely.
So, Robin, can I ask you a question?
Mm-hmm.
What do you understand public interest to mean? So we're talking about public interest lawyering. What is public interest?
Talk about a mushy term, a term that can be used both for good and bad, and there are certainly public interest law organisations, more so in the States than here, that are acting against progress, I guess, against progressive reform, what I would call progressive reform. So it is a hard term to pin down. I guess I think of it as seeking to achieve progressive social change that improves the outcomes for particularly the most marginalised and disadvantaged and those who have no voice in our law or legal system. Partly it's about promoting the fulfilment of existing rights, recognised rights. Partly it's about pushing the law to perhaps recognise new rights, where it has really seen power as the main holder of rights. So the idea of law becoming more cognisant or inclusive of diversity and of marginalised groups, and having a way for them to be heard in the power structures. It's about identifying the ways, for me, in which laws, legal systems and other systems operate to undermine people's rights and equality. And I think importantly, sometimes easy to forget this, I think for me, public interest also is about enhancing democratic processes and accountability. So using the law, things like administrative law as a tool for public interest lawyering is really important. And you talked about cause lawyering. People talk about movement lawyering and reb lawyers. So there's a sort of reb law group. Which one are you?
Good question. I don't know, do you identify as a particular type of lawyer? But I think, you know, in the environment context, are we movement lawyers? Perhaps we are. The work of the EDO doesn't occur in isolation. It's part of a range of different movements, the climate justice movement, the environmental justice movement in the US, which really stemmed from that idea of environmental racism, that we impose burdens on people because of their colour, because of the suburb that they live in. But there's a whole range of, there's a whole range of other movements there that you sort of sit within. But we also do, that work for people who don't have anywhere else to go, who have a mine at their doorstep and they don't know what to do about it. So it's not just about being part of the movement, it's about promoting justice and sharing the power, because we have that power.
Yeah, it's one of those privileges, isn't it?
Yeah. Robin, what sort of litigation, what are the tools that public interest lawyer uses in public interest strategy?
In terms of litigation strategies, I guess at PIAC we, I think, used all of them. So, and there's probably some others, somebody in the audience will go, but you didn't say this one. So injunctions, so preventing something from happening to enable the full dispute to be heard properly. And injunctions are an interesting tool, sometimes tricky. Class actions are the one that students always wanted to get us to teach them about. So we ran a course called Practicing in the Public Interest for later year law students in New South Wales. And everybody wanted to know about class actions. My staff didn't want to know about class actions because they're really exhausting and they can drag on for decades and usually do. But they also can achieve extraordinary outcomes if you can get it right. But I mean, the good thing is we now have law firms that specialise in class actions that will work with social justice movements to run those sorts of cases. One that we used quite a lot was seeking to intervene as amicus, so a friend of the court. It's not as popular here in Australia, not as common here in Australia as it is in the US. You look at some of those big US cases and there'll be dozens of amicus briefs being filed by interest groups. In Australia, it's much more common to see one or maybe two amicus or amici briefs filed, and it's a really uncertain strategy, which is why from the lawyer's point of view, it's not always the best strategy. But it's also a strategy that I don't think our courts have really embraced. And that's a problem because, I mean, our courts look at disputes between individuals, but those disputes have an impact on other people as well. Test cases is the classic. You know, one individual has a case about an issue that if we get the right outcome will make a difference for a much bigger group of people. Use of judicial review, challenging actions on the basis they're ultra vires, so you're sort of those lovely things. And we were talking the other day about mandamus. I've always wanted to bring a mandamus action just because it sounds so good, and I've never had the chance, but I think you said you'd done one recently.
EDO last week, the New South Wales EPA released its climate policies, draft climate policy, regulating for the first time greenhouse gas emissions. Why did they do that? Because we successfully obtained a mandamus remedy against the EPA to produce a climate policy. The courts intervened in the lack of policy in the aftermath of the 2020 bushfires, those catastrophic bushfires. Our phones ran hot after the bushfires. People wanted to know what they could do. And we worked with a group called the Bushfire Survivors for Climate Action and took an action to get action at the state level on the New South Wales EPA to produce a policy, and voila, they have now produced a draft policy and the work begins.
So it's interesting because there were two of those beautiful Latin terms in there, ultra vires, which means acting beyond power, and mandamus is sort of forcing somebody to use the power they have got to do something that they've got a duty to do. So both of them are really important if you think there's a gap or an overreach. And one of the things that I was thinking about is when one of the things that groups like PIAC and the EDO do is we go public about our public interest lawyering. So we use the media, and that's always, can be a bit sensitive in legal practice to go to the press. And so you have to be careful. But I know there are cases that we're involved in, including test cases against airlines that spring to mind immediately, where we went public, and we had a stunt because stunts are quite a good public interest strategy, where we had several people who used wheelchairs at the airport who were talking about their experience with the airlines. And that happened. This was not my idea. This came from a barrister friend in Sydney. He said, I think we should do a little bit of a stunt on the day of the directions hearing, which is the most boring part of the legal process, really. It's where you just set down what's going to happen in the process. You wouldn't think the media would be in the least bit interested in a directions hearing, but we had national media across all of the channels, and every network, every newspaper picked it up because it was, it had good visuals. It was against the airlines. They're really easy to hate. And we got a very speedy settlement in that case, one that we didn't really expect to get. And I suspect the media attention helped with that. So while the legal bit of it is an important part of the strategy, I guess one of the things that public interest lawyers are always thinking about is the campaign that sits around it, the media campaign, the bureaucratic campaign, the public, the community campaign, the grassroots stuff, and that we work with those groups to support the outcomes they're seeking to achieve. We're not the hero lawyers, we're the sort of, we do the utilitarian work of law.
That's right. We produced the case, and in the case of the EPA case, we produced a policy, gave it to the EPA and said, this is the policy that you should implement. And then the bushfire survivors for private action with incredibly compelling stories. You know, they told their stories in the media, and that's been a key part of that strategy.
Yeah. So you certainly learn about the other skills that can move political change or achieve political change. And it's not just the lawyers, it's a whole bunch of other people. And in your work, it'd be scientists and all manner of others. So one of the things about public interest lawyering is I think that in Australia and probably in most of the Western world, the general community has pretty high expectations of the law, and I suspect in part because we see lots of really interesting dramas, courtroom dramas from the US. So Erin Brockovich, why can't we all do that? Do you think those expectations are achievable here? Are they met? Are they achievable? And if not, what are the issues here in Australia?
That's a really great question. There's a couple of issues. The starting point is really that Australia has a different legal system to the US, and costs against unsuccessful parties is a key barrier to any public interest litigation. That cost barrier doesn't exist in the US in the same way. So comparable, like for instance, there's a case being brought by children against the state over the United States. It's been on foot since 2015. It's called Julian in the United States. There's a great documentary about it that everyone in this room should watch. But why can they take a case that's been running for 7 years? Because they're not exposed to costs in the same way that we are.
And Sharma would be the equivalent.
And Sharma is the equivalent case, but it was a much tighter ask of the courts than a 7-year case against the government, arguing that there's a duty to preserve the environment because there's a public trust in the Constitution. That's going to take a long time to hear, and it's been kicked out of the courts in appeal and back again about 3 or 4 times. Redressability was the key challenge in that case, as in, does the court have jurisdiction to grant the order that we sought, which is basically the same order that we sought in the EPA case. But costs. Standing is the other one. I want to ask you about standing because standing in PA's world is a key issue. So,
yeah. So for the non-lawyers amongst us, standing means the right to bring a case. So you've got a sufficient interest in the dispute to get the court's attention. And in Australia, standing laws are tight, would be a fair way of putting it. And for us, that was always an issue at PAC. You've got to, if you've got a campaign, you need to find somebody who's got sufficient interest in the dispute to be the plaintiff in the action. And that can be really tricky. And I will also say, and I'd say this to students when I was teaching this stuff, and they raise their eyebrows and go, that can't be right. You also want the right plaintiff with standing because it does make a difference. You want one who can't lose their house and everything else, so the costs issue becomes an issue for standing as well. And you want somebody who the courts will find sympathetic. So there are 2 classic discrimination law cases that I think are interesting in this sort of context. One is called Purvis against New South Wales Department of Education, and the other one is called Finney against Hills Grammar School. They ran it around the same time. They were both kids with disability being excluded from schools because of their disability. Daniel Hogan, who is the child in the Purvis case, had quite severe physical and developmental disabilities and would lash out. He not do very much harm, but he'd certainly lash out, and was not a particularly sympathetic plaintiff in lots of ways. And he got thrown out of state school because of concerns about risk to staff. Scarlett Finney, and he lost. It went all the way to the High Court Court and he lost, and the High Court talked about, oh, well, you know, what if he burnt down the school? Well, he didn't burn down the school. He did nothing like burning down the school. And in fact, somebody else at the school had tried to burn down the school, hadn't been expelled. So that was a sort of, you know, classic case of let's turn this child with disability into the devil kind of stuff. So quite nasty, negative stuff about him. He lost. And you sort of go, well, where does the child go if the state school system doesn't take them? That continues to be, for me, a real challenge. Scarlett Finney, on the other hand, was the cutest child you could imagine. She had Shirley Temple curls, dark hair, Shirley Temple curls. She has spina bifida. Despite that, at the time, she was very mobile, and in the court hearing, she was clambering over tables. It's like she was very physically able. They excluded her, the school excluded on the basis that they'd have to make physical adjustments to the campus, and that would cost them too much. And they actually said in their letter refusing her admission that it was because of her disability. That's a gift to a public interest lawyer. I don't get them very often. Scarlett won, and I can't help thinking that Scarlett, being cute and articulate, she's 5 years old and she's talking to the media and saying things like, I just don't understand why I can't go to the same school as my brother and sister. But, you know, that's just absolute gold if you're a public interest lawyer. So in both cases, they had standing. The interesting thing with Daniel Hogan is he was a foster child. So his foster parents had to establish that they had sufficient interest in his future. So standing was more tricky for him than it was for Scarlett's family. But standing it's so often the problem when you think about marginalised communities and you've got systemic problems. So systemic barriers to justice affect a whole lot of people who has sufficient interest in it. And I can't help thinking, and might seem like a sort of an aside, but things like when there's issues about constitutional, whether or not a person can stand for Parliament federally because they, you know, are from New Zealand or wherever else, who has sufficient interest in that? And yes, there were challenges, but that's always, you know, those sort of cases you think you've got to find somebody who can argue an effect on them. And Michael Kirby's written a really beautiful paper that I've got a copy of here, where he talks about why is our legal system so antagonistic towards public interest litigation, and he talks quite a lot in that about standing and the idea of excluding obnoxious busybodies from the courts. And it's like, well, you know, why can't a disability organisation bring a claim on behalf of a community of people with disability? But I was involved in a case where we tried to do exactly that, and the federal court threw us out on standing and then ordered costs against us. That's always a nice outcome because they found that it wasn't a public interest case because we'd lost standing. So anyway, you get those sort of very narrow interpretations in the court. So standing is, I think, particularly problematic in marginalised communities, and where you're talking about the environment. Who has standing in the environment? What a good question. And, you know, one of the things Kirby talked about in his paper is he talked about the closed doors of the courts. And really what we should have is screen doors to keep the pests out, but not be quite so closed as the sort of big oak doors that we have on our courtroom. So, you know, I like that analogy. I think it's quite a nice way of thinking about it. And, you know, people come and try and get standing expanded in various issues. And I know it's not the same in the environmental sector or in parts of the environmental sector.
Yeah, it's interesting because it is still an issue. I mean, every single time we're advising on a case, we're advising on standing. I was talking about it with a client literally today. But you know, there's case law now from the High Court around standing for public interest litigants in the environment sector. So most of the time, to avoid the costs issue, organisations take legal actions in the environment, and organisations will have standing if they've got a special interest in the subject matter. You still need to demonstrate standing, but it's less challenged, in particular in the federal court. It may be more challenged in some of the courts, maybe in Western Australia or the Northern Territory, but hasn't been challenged for a while when you're talking about an environment group. There's also an open standing provision in the Environment Protection and Biodiversity Conservation Act, our national law, which for 9 years has been the subject of the government trying to repeal it to stop so-called lawfare. But really it's just saying that anyone can take a legal action relating to the environment. I just can't see how that's a controversial opinion. But that's a different, that is one of the few exceptions. There's a similar provision in the New South Wales Environmental Planning and Assessment Act. And there are merits review. There's the ability to take a merits review. For instance, if you lodge an objection to a development, you usually have a right to take merits review if that is approved or on conditions. Those protections are being whittled down, so I'm not going to say that that's across the board, but there usually are those sorts of protections in Tasmania. That's the Tasmanian Civil and Administrative Tribunal. But that's only if you're an environment group. If you're, for instance, it's a great case, it's a terrible case really, but it's a great example of what the issue is here. In South Australia, there was a red dust that was affecting the town of Whyalla. And the township formed this group called the Red Dust Action Group to protect themselves from costs and take legal action to prevent dust entering in their house. Children were having trouble breathing. They led all of this evidence about the complex problems created by the dust from this mining activity. And the court found that, yes, there is a problem, but I'm not going to grant relief because you're not affected by the decision. You're not a person affected. You're a group. The group can't be affected either, the members are. So it really depends on the particular law. And if you're, I've been standing as still, obviously an issue for getting a levity deadline.
Yeah.
I want to ask you about costs, Robin. Yeah. What are we talking about?
So we're talking about the idea that in Australia, as you said, if you lose, you pay the other side's legal costs. So the costs, or at least a significant percentage of what they are paying to have legal representation. And given power imbalances in law that already exist, so, you know, a lot of the cases that I deal with are individuals against corporations. Corporations tend to spend money more readily on legal fees than individuals because they've got it for starters and it's tax deductible next and a few other reasons. And that can add up to a lot of money and it's a really big fear. And certainly in discrimination law in Australia, the majority of jurisdictions are they have a presumption against a cost order. So that's really great. It means that in the states and state and territory tribunals, if you lose, it has to be extraordinary. You have to have done something really, really bad to get a costs order made against you to pay the other side's costs. But in the federal system, at the moment, we still have a costs jurisdiction. So it means if you go to the federal court on a discrimination claim and you lose, you're up for almost inevitably an order for costs. And that runs into tens of thousands, hundreds of thousands of dollars in some cases. You know, you hear about the really stupid cases where it's millions of dollars. We just recently had a case here in Tasmania, David Cawthorne against Sitter Group. So this is an individual with a physical disability who challenged the Parliament Square development because one of the most significant entry points is not accessible to him. And we never got to the argument about whether or not it's in breach of the law because we ended up in an argument, and this is another risk with public interest litigation, we ended up in an argument about whether or not the tribunal had the authority to decide the case. The tribunal found that they didn't, and this got argued or notified to the parties a week before the tribunal substantive hearing was about to start. So all the experts were lined up, everything was ready to go for a week-long hearing, and his lawyers got notice that they were going to argue the tribunal didn't have jurisdiction. Great. Anyway, so the tribunal heard that argument and nothing else at that stage. 11 months later, they decided they didn't have jurisdiction. So it took them 11 months to determine that. Meanwhile, the development's going on over here. He went to the Supreme Court on appeal of that decision. The Supreme Court held 3-0 that the tribunal did have jurisdiction and should have determined the case, sent it back to the tribunal. Sitter Group sought leave to appeal to the High Court, got leave. And this is where it got interesting, because once you're in the Supreme Court, in the Supreme Court, David won, therefore costs were awarded in his favour. That was quite good. Go to the High Court, you're talking about, another bundle of money being spent on legal fees. And in the special leave application, the judge, and I think, am I going to remember who it was? Decided that there would be no costs, that in fact the respondents would pay the costs, because they wanted this argument run, and David was an individual pensioner, all those sorts of things. So that's really unusual. Like, it was mind-blowingly unusual to get that kind of order from the High Court. So the case went into the High Court in the knowledge that there could not be a cost order made against David, which was really extraordinarily good. The High Court found against David, and so that was potentially the end of the case, although I know there's moves afoot to try and challenge it in a different way. But had he lost in the Supreme Court, he would have been up for a costs order inevitably, even though the tribunal isn't a costs jurisdiction. So once you move out of a no-cost jurisdiction into a cost jurisdiction, you're in trouble again, and that can be a real difficulty. There are some strategies that we use and continue to try and use. Some of the courts are getting more familiar with the idea of putting a cap on the costs that they will order. So you apply to them and say, we think this should be capped at, I don't know, $15,000, $30,000, so that the more impoverished of the parties, which is almost inevitably plaintiff in the work I do, knows what the biggest risk is they face. And the first costs cap that was ordered in the federal court was in a human rights case, was in the case against Virgin Blue, the airlines case that I mentioned before. We got a costs cap, which meant that the two plaintiffs in that case knew that the maximum they could have ordered against them was $30,000. It's still quite a lot of money for most people. We also, so that was one really good strategy. The court's got to be willing to use its discretionary power, but in that case it was. In New South Wales, they have this fabulous system, or they used to, where if you got a grant of legal aid from the New South Wales Legal Aid Commission, there was an indemnity that came with that. So if it was a state matter, you're completely indemnified for any costs order. So legal aid would pick up that. If it was a federal case, which this was, they would indemnify up to $15,000. So we knew we had a cap of $30,000 and a $15,000 indemnity. So the maximum amount clients could end up paying was $15,000. That was really important to them because both of them were working and both of them stood to lose house, car, everything else. So those sort of schemes, and I don't know if any other state or territory has it. It's one of those things I always...
Yeah, I think Victoria has the
excellent indemnity fund, fantastic. There are also now what we call indemnity funds, so Grata and others who will basically take the risk in a public interest case. I'll say we'll cover the risk. It used to be that you couldn't do that kind of thing, but the laws have changed, which is good. And certainly funds like Grata have been really important for public interest litigation. There's also, interestingly, a Commonwealth public interest and test cases grant scheme. And it used to be useless because you couldn't apply for it until after the case was finished, which is a little bit late if you don't get the funds. But now you have to apply in advance, so that was good to see that change. And they are looking for an uncertainty in a legal principle that needs to be determined. So if you've got that, or something impacting disadvantaged groups. So they're the criteria for those. So costs really matter. And this is the stuff that you never learn in law school. Or maybe you do in Hobart. I didn't go to law school here, but I didn't understand standing or costs until I started practicing. And for us, they were the most important two issues that we dealt with.
Yeah, that's right. And the other thing that is often used in our cases is we ask the court to exercise their discretion favourably because it's a public interest case. Now, that requires you to take all the cost risk and wait to the end and then apply to the court and ask them for their good graces. But In New South Wales, in the Land and Environment Court, they've actually got provisions for public interest cost orders, which are favourable, as in the issue. Reverse onus, like you should get a public interest cost order unless it can be proved otherwise. And it's really important that the laws allow for that and guide judicial discretion, because I think one of the biggest challenges is that it depends on what the judge thinks on the day. It's discretionary. If it's not in law, if there isn't this obligation to consider that, then you're really just chancing it on the day. That to me is one of the as well. Gratified actually has done a really great report recently released on what those sorts of cost protection laws look like, and I really which we contributed to as well as many others, yeah, that's a great report.
And one of the interesting things I and all of my colleagues in discrimination law land want the federal system to change to revert to being a non-cost jurisdiction, but we're actually pushing a step further than that, and that is a system whereby a plaintiff can get costs ordered in their favour almost as of right, but a respondent can't. So it's a sort of additional way of thinking about it, on the basis that people are bringing a claim under a law that is set up for the public good. So discrimination law is seen as something that benefits the whole public, but we oblige individuals who are very disadvantaged to be the ones who pursue the enforcement of that law in Australia. So certainly there's some interesting things coming out of the reforms flowing from the Respect at Work report, and we saw a draft bill that does include some really interesting shifts in costs and standing issues federally. So that could be, watch the space for that stuff. Before I move to the final sort of set of questions, anybody want to ask us anything? Anything that's burning in your brains that you want to ask us about?
I have just a question about taking on, because you mentioned sort of like clients and like finding favourable clients. What about where the sort of you need to take on an unpopular client? Because like one of the big examples I can think of public interest lawyers was the defence by Michael Mansfield of the Guildford 4 and Birmingham 6 in the UK, where the appeal was incredibly unpopular in England. And will there be cases where in your organisations where you feel you have to take on people where it's going to make potentially hurt the public relations of your...
Yeah, I mean, I think that's much more common for criminal lawyers than it is for us who aren't criminal lawyers. But I think it's a really good point that, yeah, sometimes you have to take it because it's such a significant issue and really requires the best possible legal counsel. And one, I guess, that an analogy in Australia that I can think of is people who pursue strong cases around refugee protections. Not necessarily all that popular, or I think they're probably getting more popular, but there's certainly a cohort within society who think that that's, the people shouldn't have those rights to stay in this country. And that's where having a community group around you to do some work in the community to try and change that public perception as well really matters. It also really helps if at the end of the day, win or lose, you've got a campaign that highlights the injustice that comes from that kind of case. So, yeah, really interesting problem, the unpopular party. And I guess, barristers are obliged to take the next client. The cab rank rule says that client comes to you, if you're free that day, you're supposed to take the case. I think I would say, I doubt that's exactly how it happens, but, there's always that protection as a lawyer to be able to say, well, everybody has a right to representation. Somebody's got to represent this client. So, yeah. Question, did you?
Robin, we've got a question online, if I can duck in, from Michael Bleasdale. What outcomes were achieved, for example, with airlines? They are still rubbish. So did they learn for one day and then forget? And so do we need a different strategy beyond the law to activate lasting change in this and many other areas of service delivery and policy relating to people with diversity?
Absolutely, thank you, Michael. What a great question. So at that stage, what it was about was requiring people with physical disabilities to always travel with an accompanying person, a carer, even if they didn't have a carer in their day-to-day life. So twice the airfare. And when you get to the other end, you've got to pay for their accommodation, and then you've got to fly them home with you. So they were requiring that. And one of the things they said was because if there was an emergency, they couldn't put their own mask on. So one of the questions we sort of somewhat cheekily asked was, what do you do with kids? Do you just leave them, just worry about somebody? And they said, we always ask the person sitting next to them if they'll put the mask on to them. So in that case, they changed their policy, and they still don't impose that policy, which is great. It means that, at least for some people, the cost of airline travel is half as much as it would otherwise be. But yes, legal change doesn't mean social change, and it doesn't mean sustained industrial change. And I think that's where the best public interest litigation, from my point of view, happens in the context of a much bigger campaign. And one that strikes me, that I always think of when I think of this, is Al-Kateb, which was a High Court decision that found that indefinite detention was fine under Australian law. But because of the community campaign, particularly from rural Australians for refugees and groups like that, there was such a sustained campaign about the injustice, and the fact that our court had said, well, you can indefinitely detain somebody, which seems such an anathema in a free country, that despite losing or despite winning, the federal court very quickly brought in a new visa class to allow people to move out of detention into community. Now, that wouldn't have happened if Al-Kateb hadn't been part of a much bigger campaign strategy. I mean, I'm not rah-rahing the immigration system and the refugee rules, but it was a really important thing to have that other work around it.
Yeah, it's also important, though, to have the right laws to start with. If you don't have the right redress, then you're not going to be able to take an action. Great example of what's wrong at a federal level is we don't have a Human Rights Act. Let me say that now. We don't have a Human Rights Act. There's no Human Rights Charter, unlike other countries. And because of that, some people can't seek redress. And even in the states where we have human rights charters, they're only enforceable against public authorities, and you have to have some other remedy to piggyback on in order to raise a human rights issue. So, there's other things that are wrong. There's still a lot more work to do.
And I mean, in terms of having the right laws, Michael works in the disability sector like me. Our discrimination laws, as I said already, rely on individuals who are affected to bring a claim. That's pretty intimidating for most people, and you have to have got to a pretty serious tipping point before you put up your hand and go, life is so appalling, I'm going to actually I'm going to take this next step. So that's the first problem. The remedies that are available under discrimination law look on the face of it to be broad and exciting and lots of potential, but the courts don't use and certainly don't look for systemic remedies. And that's a real problem. And I guess I looked to the US, where things are slightly better in this space. They have a prosecutorial model, so the Federal Department of Justice can prosecute breaches of federal discrimination laws. And they will bring class claims. And it's quite hard to bring a class action under discrimination law as well. That's going to change, I hope, with the federal reforms coming through. But they will bring class actions on behalf of, for example, everybody who lives in New York, or these crazy big claims, and they get crazy big settlements. And partly the financial settlement matters. So here, there've been a couple of big cases that have got big compensation remedies, but mostly we're still talking less than 100,000, often less than 20,000. That's not a very big disincentive to discriminate in Australia. And while not sure big sticks are the best option, there's certainly an option that gets people's attention. And I know from my practice in private practice that clients would say, well, it's pretty low risk. Why would we put the money into fixing that problem? The chances of a claim coming against us are small, and we'll settle it for less than 10 grand. And that's a real problem without prosecutorial models and proper regulatory framework. So that's part of the problem that Michael's alluding to, I think, is that we really don't have laws that seek to redress the imbalance of power in our society as much as I would like, as you know, and sort of my frustrations with the law. Yeah.
I don't know if I'm going to, well, I'll ask my question. I think I probably know the answer, but maybe it'll go somewhere interesting. I'm thinking about reform of the process, and just wondering if there are any jurisdictions that you know of anywhere that have either particular divisions of courts that handle public interest cases. You know, like you could have that would have special rules around, or particular rules around standing around. I mean, this is obviously I'm trying to. We have particular issues in Australia that don't apply elsewhere, but I just was thinking, you know, more broadly, if there are such things.
Yeah. The best example, it's a really good question, because it's like the forum is important, right? And I'm thinking about this in terms of, you know, disability discrimination cases and needing to have the right plaintiff. What do those particular judges, you know, have in terms of lived experience of disability to be able to, you know, properly judge that case? But the best example that I've got is the New South Wales Land and Environment Court, because it's a specialist court. It deals with environmental issues every day. It treats them in a different way. You go to a magistrate's court on a civil enforcement or a prosecutorial matter, you know, they're dealing with difficult violence and assault like every day of the week, and then you say, oh, there's been some land clearing over here. Not sure that they care as much about it. But the Land and Environment Court is a specialist court, has specialist rules. It's based on a concept of being able to bring actions. It's got really good rules around costs protections, and it's a great model. You know, it's not perfect, but it's a great model of why you need to have specialist judges sitting on those sorts of specialist cases. Discrimination, no doubt, is another area, because there's a whole lot of context that you're missing if you just get a case when you don't have the background.
And in the federal system, and this is part of my PhD coming to mind, I looked at all of the federal decisions in the different courts. So there are two levels of courts that deal with federal discrimination cases, the federal court itself and the federal circuit court. You would be incredibly well advised not to go anywhere near the federal circuit court if you had a discrimination case, less than 9% kind of success rate. And you look at the makeup of those courts, there are increasingly women on the courts, which is great. There's very little diversity beyond gender diversity. And in discrimination cases, despite 50% of the federal circuit court being women, only about 10% of the discrimination cases are heard by women, because they're not in that jurisdiction. And the federal circuit court has a vast jurisdiction, you know, it does bankruptcy and admiralty and family law, and discrimination makes up this tiny wee little bit of it. And you know, I had this dream that we could have a single national discrimination tribunal that would deal with all discrimination cases, whatever law it came under. So, you know, whether it was a state case or a federal case. So you could have a small body of really expert judges, and you could have what they have in New South Wales, which is a true tribunal, which has one legal member and two community members, people who bring expertise beyond the law to the process. So they're much more likely to have experienced or seen discrimination, how it plays out in their particular communities. So there are things we can do differently. And the New South Wales Anti-Discrimination Tribunal I think was probably the best tribunal in Australia when it operated, because it had that full tribunal model. So yes, there are things you can do that we can do that are different.
But also, you know, representation in the profession is really important. We talk a lot about women's representation. One of the things that's amazing about the EDO is it's given women a really amazing opportunity to lead, which is quite rare in the profession. Difficult to advance, but not just women. I mean, I think we need to look deeply at our profession and about inclusion in the profession. Sorry, someone else had a question.
I am going to out myself as definitely not legal minded, because it might be a really obvious question. When you're working with people from disadvantaged backgrounds, obviously the legal process takes quite a toll. A lot of mental health advice, which is the space that I come from, is like acceptance, commitment, like it's being okay with what there is in the world around you. But this process requires you to be the exact opposite and be quite passionate to not have that. Are there cases or systems that you either decline to represent someone because you are concerned for their welfare through the process, or are there, I guess, mitigating factors that you have within the process that helps protect the people who are representing these big and important issues from a place of vulnerability, where they've often come to the scenario in a vulnerable place that is going to be particularly triggered by the things that you are needing to go through to get to the other end of it.
That's a great question. Nothing wrong with that question at all. No. Certainly, I think one of the things that as a practitioner I try to do, and I think it's the right thing to do, but others might disagree, is to really talk to people about those issues around, this can get really exhausting and draining, and one of these, this is an important one, you'll have people around you who are a cheer squad, but they won't be there to carry the can if you lose. So your cheer squad, you actually need wise friends more than you need a cheer squad. Cheer squad's quite useful from time to time, but they'll be geeing you along to continue the fight, and that may not be the right thing. And the more you have a cheer squad, the harder it is for a person to say, I actually don't think I should continue, because a whole lot of other people get disappointed. So that stuff is a really important part of being a good lawyer, I think, about helping people to reflect on whether they've got sufficient support around them. It's one of the beautiful things about class actions is you've got a class of people and you can actually get the class to develop and work with the class to develop a bit of a support network, but that's not usually the case. And it's why having good advocacy organisations is really key, because they can also be looking out for people's wellbeing. But I think that wellbeing stuff is really underdone. One of the things I think we learnt a little bit to do a little bit better during the Institutional Abuse Royal Commission was the support of people who are witnesses in those cases. And there is quite a lot of work going on globally, particularly that I know of in the English-speaking world, to recognise that witnesses, that it's really hard to be a witness. It's even hard to be a plaintiff, but it's really hard to be a witness. And we put people in extremely difficult positions, and our legal system, the adversarial nature of it, means that people get torn down, like literally, like it's almost literally torn down. And unfortunately, sometimes the lawyers who do that are put up on a pedestal as being really hard, tough nut lawyers. And I think that's really problematic, because you're not winning because you've got justice on your side, you're winning because you've got bullying and power on your side. And I've had lots of people say to me, but what they just did to me then was bullying. And it's like, yeah, I'm sure that's what it feels like. It's actually an acceptable legal strategy. And the law has a lot of those that, if we could reform them out of the system, we would have a system that was more about justice than it is at the moment. I think it's a really great question, and I think we need to do more and more to think about it. I know the current Royal Commission, the Disability Royal Commission, also is facing that challenge of how do you help people to tell the most terrible stories again, so re-traumatise themselves in order to tell our country what is wrong with lots of our systems. And they're doing a huge service to us, but we're not really supporting them as much as we should.
Yeah, we're asking, it's a really great question because it's fundamental to being aware, as in our duty is to our client, and that duty is also to care and protect for them. And I think that's one of the things that I said before, that I've gone on this journey in this role that I'm in now. I've really learnt about the necessity of doing that, because not only are you is someone asking you for help, but then going through this litigation process, costs, standing, barristers, going to court's a really alien environment in and of itself. telling the story to the lawyer, to the expert, to the barrister, again to the court, you know, again and again re-traumatizing someone in a vulnerable position. You know, it's something that we're really conscious of, and I just think that it's something that's fundamental to the legal profession, and it's part of client care. We don't really talk about it in the same way. We talk about this duty to our client, and what does that really mean? It's to act in their best interests, but that is part of the best interests of the client, and understanding, you know, what is it that you're engaging on when you're going through litigation.
We have I work for Canteen, so Youth Cancer Services, with a lot of mental health stuff. We have the opposite problem of we support so much that we're actually at risk of cultivating the leadership from the young people that we have built, rather than hearing their genuine voices through, because we're trying to support them so far that you end up with people in leadership positions who've been supported to the point where they can lead and provide their voice. So it's the other side, is that they're a little potentially too held when they get into like board positions and things, which is part of our constitution. But yeah, interesting. We need to mesh the mental health and the law stuff together.
Yeah, I think the sector does a pretty well. I think the sector as a whole, you know, is very conscious of that, and there's something called trauma-informed practice. And people, you know, have training.
I'm really conscious of the time.
Yes.
One of the things you talked to me about when we were planning this out was the idea of testing the boundaries of procedure, and the experience you've had recently with First Law and what that looks like. Do you want to just do a quick, rah-rah about how interesting that is?
Well, I guess one of the things that you think, so when you're a lawyer in private practice, when you go through law school, you think of the law as really static. These are the procedures of the court. This is how you approach the court on a particular matter, and each court has its own procedures and you comply with those. I guess one of the really exciting things and one of the opportunities of public interest lawyering is thinking about how you can do that differently, so that cases can be more ethically run, to go to your point. And one of the cases recently, well, there's been a couple, but I'll talk about the Galilee coal mine and the case by youth verdict that PDO has been involved with. And in that case, we called evidence from a range of First Nations people about the impacts of climate change. And we needed to do that in a culturally safe way. So, with guidance, put in place cultural protocols and heard evidence on country with welcome to country and all those sorts of things, resisted by the proponent strongly on the basis that it would cost a lot of money and take a lot of time. But ultimately the court went out to the Torres Strait, went to Cairns, heard from a range of witnesses in a culturally safe environment. It's the first time that I'm aware that it's been done in the environment context. It's that sort of evidence is taken in the native title context, but you can think about the procedures of the court in a different way, and we approach the court and made an application to seek those orders. But that's one of the things that can be done, is to think about how do we do it differently. And even the way that you were talking about royal commissions and the like, putting in place different approaches for the witnesses. I won't use the word victim, and I'm sorry that I did. I will retract that. For witnesses in those matters, there's some thought that can go into how you need evidence and how you approach the court on particular matters.
Yeah, and it just reminded me about a procedural thing we did once, which there was a big case going on in New South Wales in the trade. I'm going to say it's the Trade Practices Tribunal. I can't remember what it was called, competition, and one of those tribunals that I never had anything to do with. And there was a challenge to Sydney Water's monopoly. So Sydney Water has a monopoly on water and sewerage, or it used to have a monopoly on water and sewerage in Sydney. And there was a company that wanted to break that monopoly so it could offer different rates in order to encourage recycling. So they were doing it for a really interesting reason. We were worried about the impact it would have on pricing, because they were only really interested in getting customers on the eastern seaboard of Sydney. If Sydney Water lost all its eastern seaboard customers, the price for people inland would go up, and they're the most disadvantaged people in Sydney. So we had a utilities program, and we looked at this and we thought, this is really problematic. I like what they were trying to do for one reason, but really concerned about the pricing impact of breaking the monopoly. And so we decided we were going to try and have some sort of intervention. We didn't want to be amicus. We didn't want to be a party because the case was going to go for, you know, a year and a half or something ridiculous. But we really wanted to make submissions on the pricing issue. And we also wanted the environmental stuff to be addressed, but we weren't the people to do it. So we went to the EDO in Sydney and said, we're going to intervene in this on pricing, but you might want to intervene on, on the recycling stuff. So we left that to them. And we had a senior counsel and he just said, look, I reckon we should just make some submissions. And we're like, what do you mean? We're not a party. He said, no, we just, you know, deliver some submissions to the court and to the parties. If they pay attention to them, that's great. If they don't, it's not really a huge amount of skin off our nose. So we did that and the court accepted the submission and actually made orders that related to our submissions in relation to pricing. It was like, I don't know how we did that. That was like this cowboy lawyering written but so that was completely outside of any sort of procedures that tribunal would ever have had, but it worked. And, you know, sometimes it's worth just having a go. It's one of the things that matters. I guess for both of us, you've probably worked out that we love what we do, even if we don't necessarily love the way the system works. I certainly don't love the system, how the system works. I keep rabbiting on about it's not a system fit for purpose anymore. The legal system, I think, was designed for small disputes back in the Middle Ages, and we're still using it to try and resolve quite different disputes. It probably works for commercial disputes, but not so much interpersonal conflicts. But for me, it's a place where I can live my values and do stuff that I think matters. And it, you know, I don't think about it just as litigation. For me, law is about talking to people in Parliament and thinking about how the law will look if it's written properly, and you know, really trying to get in amongst the drafting stuff so that the law does the work that we want it to do, not that we think it's going to do. So all of that is part of the excitement of practicing in the public interest for me.
I feel like I'll just say exactly the same thing. So maybe I'll say, you know, I see there's a lot of law students in the room and probably there are online. It is a really exciting career to pursue, and you don't have to pursue it from day one. You can do it in a range of different ways. There's lots of barristers with excellent pro bono practices. You know, I did some great work with Australian Lawyers for Human Rights, and there's lots of those sorts of organisations. But, you know, have a think about it as a different way of approaching legal practice. Have a think about what it means as to be a lawyer in the legal profession when there's these huge issues. You know, some of the issues that we're dealing with are major issues in our society today, and what it means to be a lawyer in that context. You don't have to do it the same way. You don't have to do it the way that you see other lawyers do it here in Tasmania or elsewhere. There's a range of ways to think about being a lawyer. It's an exciting and dynamic profession, and it holds real power. But exercise that wisely and consistent with your values, because I think that's the thing that I've really learned from my time at EDO. And I feel like I'm rabbiting on, but it's a great profession. It is a wonderful profession. But there's lots of things wrong with it. There's lots more work to do.
And I guess that reminds me also that lots of people think that in order to be a public interest lawyer, you have to be a human rights lawyer or an environmental lawyer. But in fact, you could be any sort of lawyer, admin law, planning law, media law, defamation law. Like there's scope for almost any type of legal expertise in public interest lawyering. And at PIAC, one of the things that we would always have to fight off was when we recruited positions, we'd get lots of people who saw themselves as human rights lawyers, and what we really needed was greater diversity so that when a problem came in, we could apply a whole lot of different legal lenses to it, not just the classic discrimination or human rights lens. So if you're specialising in something that doesn't look anything like what you expect human rights or public interest lawyering to look like, doesn't matter. There'll be spaces and places. So with nothing further, again, I want to thank Cleo and Yvette and Tulse, and thank you all for being here. It's great to have you here. I'm certainly going to hang around for a little while if people want to have other questions and stuff. Don't know about you, you might have to get home to others, but thank you for being here.
Thank you for having me.